know who to
Thank you all for being so respectful of the 10-minute time limit. I'm impressed with the way you've reconvened here. I'm going to vary the roadmap just a little bit. Because these panelists were so scrupulous in adhering to the time limits, I actually want to give them each, and they don't need to use this time unless they feel compelled to do so. I want to give them each at least just a couple of minutes to say anything, add anything that they really, really wanted to say, but felt that they couldn't get it in because the clock was ticking toward its end. And so I'll start with Secretary Kobach and then just work down the line. Anything that you briefly really wanted to get on the table during your initial presentation that you didn't have a chance to, I'll give you a chance to do that now.
Sure. I would add one other point about attrition through enforcement, which Nora mentioned as well as sort of a signature purpose of the Arizona law. I think there's some confusion about what that is, and it is indeed one of the purposes of the Arizona law and the Alabama law, and indeed many of the local ordinances. Attrition through enforcement is simply the notion that if you ratchet up the level of law enforcement, that you will cause more people to follow the law. And that really is probably one of the most basic premises of all law enforcement everywhere. That if you increase the level of patrolling or the level of the number of prosecutions, you will deter more people from violating law in the future. It's just a fancy way of saying deterrence, really. And it's interesting in immigration law that some people make a false dichotomy, they state a false dichotomy when they talk about it in federal terms. They say, well, our immigration policies in America are broken, and we really only have two alternatives. One alternative is to grant amnesty to everyone who's unlawfully present, and the other alternative is to round up every single illegal alien in the United States at gunpoint, put them on buses, and ship them instantly over the border, or to wherever the country of origin is. And of course, this is a false dichotomy because those aren't the only two options. A third option is to actually ratchet up the level of enforcement so people start to comply with the law on their own, and that's what these state laws attempt to do. An analogy that I often use to describe this is, imagine you had a highway. Imagine if there had never been any state patrol officers on I-70 on the Kansas Turnpike between Topeka and Kansas City in the last 10 years. No one had ever seen a single car patrolling that stretch. What do you think the effective speed limit would be? I mean, people would be going 85, 90, 95. We'd have our own Kansas Autobahn. But if suddenly there were an accident and people said, oh, we've got to get this under control, this law breaking has gone too far, no one would say the only two options we have are arresting every single speeder or getting rid of speed limits, effectively an amnesty, or forgiving everyone for breaking the law. The rational response would be, no, let's arrest 2%, 5% of speeders, let's put a few patrol cars out there. Suddenly people will realize that the law is now being enforced, and people being rational actors will modify their behavior accordingly. And that's really what's happening in Arizona, and there's statistics to back it up. Between the start of 2008 and the start of 2010, according to Census Bureau numbers, again from the current population survey, which they do on a regular basis, it looks like the illegal alien population in the United States decreased 7%. But in Arizona, the population of aliens unlawfully present decreased 16% over that 2-year period. So more than double the national average. Is almost certainly due to the enforcement of Arizona's employment law and Arpaio's enforcement of the anti-smuggling law. And people say, well, okay, that's interesting. It shows that people are taking notice. But doesn't that just mean that all the illegal aliens will go to other states? Certainly some do. California has as Nora mentioned, adopted policies, or as Patrick mentioned, adopted policies that are very welcoming of unlawfully present aliens, as well, all aliens, but they particularly have taken steps to encourage unlawfully present aliens to come. But many have gone to their country of origin. We know this because in early 2008, the Mexican state of Sonora, which is the state to the south of Arizona, sent a delegation north to meet with Arizona legislators, and the purpose of the delegation's meeting was to complain to the Arizona legislature that their new 2007 law was sending too many Mexican citizens home too quickly, and that the state of Sonora did not have the infrastructure to handle this wave of returning population, which is kind of funny but basically saying your law is working too well, and we don't have the housing infrastructure, we don't have the infrastructure to handle all these people coming back. So it does encourage self-deportation back to the country of origin too. We don't know the percentages, but it works both ways.
Dean?
Since I realized I promised to talk a little bit about pro-immigrant legislation with respect to criminal law in the states, I probably should do that now because I did cut that out. And I thought some of this may be quite interesting because it fits into explaining the reactions, especially of some police officials, to some of the legislation that is currently being considered or passed in the states. Now, first of all, one of the big debates is about inquiring about immigration status and at what point and of who you inquire of immigration status. We've talked about the traffic offenses. Many states do not inquire about immigration status at that point. One of the biggest concerns of many police commissioners is that if you have a policy of inquiry, victims would be more reluctant to come in. And there is, in fact, a indication that undocumented immigrants in particular seem to become ever more the victims of crime, in part because the people who offend against them know that they are very reluctant to go to law enforcement authorities and ask for assistance. Now combine that with the fact that many of them cannot open bank accounts, for example. They do not get their paychecks deposited into a bank, but it's all a cash economy. So you can imagine that they're carrying not huge amounts of money, but by their standards on payday, obviously large amounts of money. They get robbed and they do not feel in a position to go to the police. So what that does, it seems to me, for police and also immigration authorities, that it really handicaps them, because presumably those are the people we do want to arrest if they're citizens, and we also would want to deport if they're undocumented, because here you have the double situation of somebody who commits crime and is not in status. The other issue that's coming up in a few states now is this issue of the driver's licenses. Shouldn't states give out driver's licenses, because after all, at least here we have some kind of security check on who is driving in the cars. Of course, the whole issue here is this debate over the fact that we're using driver's licenses for a lot more than driving. You know, flying here, of course, what was I showing? My driver's license when I got on the plane. So we don't use it just as a function of driving. But a number of the states are struggling with that question, and many of them that are calling this really a public safety issue, that they want to give out driver's licenses to anybody who drives on the street, so they have an upfront control over their ability at least to read traffic signs and do things of that sort. You also have a few states that directly, in fact, impacted the federal government's power to deport someone. The state of Wisconsin, for example, changed the penalty level for misdemeanors. And what they did is they changed the maximum penalty from 365 days to 364 days. Really sounds irrelevant to you, but at 365 days, you are getting eligible for deportation because it's a crime that carries a sanction of a year or more versus a crime that carries a sanction, deportation of a year or of less than a year, in which case there is no deportation sanction that attaches. So that makes a huge difference on immigration law. It makes virtually no difference, as you can imagine, whether you could be penalized with up to 365 or 364 days. I assume if deterrence is our concern, we can care less, and probably on retribution as well. But that was clearly driven, that reform or that change in the criminal law was clearly driven by the state's consideration of what that does on the immigration side. I just want to mention one other development which has not caught on among state governors, but the last governor of New York came up with the idea that he wanted to give immigration pardons. And in fact, what that means is governors can obviously not pardon on the immigration side, but they can pardon criminal convictions. And under federal immigration law, a pardon, in fact, makes that conviction ineffective for purposes of deportation or immigration consequences. And so Governor Patterson had pardoned a number of people. These were all so-called green card holders who, however, had spent some of them quite substantial time in prison, but then not been deported at that point, which technically at this point they should be, but have the time to live in the state of New York, rehabilitate, and in his opinion, substantially contributed to the welfare of the state, and there would be no purpose in deporting them. And so rather doing this kind of piecemeal as he had been, when he noticed that there was this big issue in his opinion, he set up, in fact, a special panel for people to petition where the major consequence of their criminal conviction was deportation. And before he left office, he issued a number of pardons with the assumption that they would either wipe out deportation as an option, or at least give the person the opportunity to make a discretionary plea to stay in the country. So that's another way, in fact, for state executive authority to impact federal immigration law. So you have a lot of interplay, and much of it, I think, so far has been hampered by the fact that there's very little known often in the states about when immigration consequences attach, and often even in the criminal justice system, there's a lot more education needed to assist people in figuring out when deportation can attach. And then, of course, what you'll see is state prosecutors making decisions whether they think that is the sanction that should also attach aside from the criminal sanction. So I think that we will also see as a consequence of the Padilla decision I mentioned to you, and that may change quite a bit in terms of decision making in the criminal justice system in the states. So immigration, federal immigration, will have a dramatic impact there.
I don't have too much to add. I do want to discuss just some food for thought, I would say, concerning the spheres of government between federal and state power. To reply kind of both to comments of the Secretary and the Dean here. The first is that the Secretary is correct that the executive role is to enforce the laws as they are. This includes the laws that we don't want. The executive does not go and say, that's an old law, I don't want to enforce it. Until Congress removes it, it is a requirement to be enforced, and whether you want to criticize the Obama administration or not, he's done a pretty good job at enforcing immigration law, at least in my humble opinion. But also I think Nora brought up a great point too. This idea that we're punishing citizens and lawful immigrants for assisting unlawful immigrants and the constructs of our federal state authority, and what should we think about in terms of that? Well, let's go to 1986 employer sanctions. The idea it's employers' civic duty to ensure that we don't employ unlawful immigrants, and they thought that was the best humane way because we as citizens, we should enforce the law. We should assist in enforcing the law in whatever way we could. We don't rely on the government for everything. In order for deregulation to occur in any aspect, it's going to require the use of citizens assisting. But what Nora brought was interesting is should we punish citizens per se in doing that? Is that good policy? And I think it's a two-sided coin. If we use the framers as a guidepost, we would say it's there's civic duty to ensure the laws are obeyed and enforced. At the same time, today in today's society, we're much different. We're an individualistic society. We don't want people telling us what we should and should not do, and that is completely different than the 18th century society that was created. So it's just some things for food for thought. When we think about immigration reform moving forward, what are the purposes of these laws and whether it is good policy.
Thanks to the three of you for those additional comments. Okay, now we're into the part of our roadmap where we'll create a little opportunity for the three of you to respond and question each other regarding what you've heard. You've done some of that already in this little preview that we've had over the last few minutes. But I open the floor to the three of you. Responses, questions that you have regarding what you've heard from the other panelists who shared thoughts this morning.
I'll throw one response at each of my fellow panelists. And I agree with a large amount of what Nora has said, and Patrick, some first names, I get what.
Yeah.
Okay. And Patrick has said. But I will quibble on a couple of points. Nora mentioned, and I particularly like her observation that it's incorrect to assert that just because there's federal legislation in an area that there is federal uniformity in an area. That's not true in immigration law. It's not true in a lot of areas of law. And so I think there's a myth out there that, well, anytime the states act in any field, you create a crazy patchwork quilt, and that's a bad thing. And the uniformity of law enforcement is really a myth. But the point I'll quibble on is she expressed a fear that assisting illegal aliens being made a crime of conceal. If it's a crime to knowingly transport or to conceal an illegal alien, that could create a problematic culture of people not, wanting to provide humanitarian assistance to others, and that would be something we should shy away from. And I would simply point out that those provisions of the Alabama law were taken word for word from federal law, and they're found at Title 8, Section 1324A1A of the Federal Code. And it's been for more than 50 years, it's been a penalty to knowingly shield, harbor, or transport an illegal alien in furtherance of their continued presence in the United States. So if it would cause these bad social consequences, we would have already seen it, since it's already been federal law for so many years. So I don't think Alabama is likely to cause any sort of great social shift in the way people are treated. And then, as to Patrick, I would throw this out, and I agree with a lot of what Patrick said too. Although what I would disagree with is his assertion that states can only act in the immigration arena when they have express federal permission or express authorization in order to be consistent with our constitutional structure. I think that argument was rejected in the 1840s in Gibbons versus Ogden, when the Supreme Court, looking at the commerce power, said there is no automatic displacement of the states when Congress has not spoken. And that was, of course, when the court started formulating its doctrine of the Dormant Commerce Clause. There's no such thing as soon as Congress has permission to be on the field under our Constitution through its plenary powers listed in Article 1, Section 8, then suddenly the states are off. And the same holds true with Congress's plenary power over immigration. Just because Congress has authority to create a uniform rule of naturalization doesn't mean that the states have to be given permission before they act. And that's why the 19th century, the bulk of which was regulation of the states in the immigration area, was not an aberration. That was perfectly consistent with the constitutional order of the framers. Once the Congress gets in the game, to be sure, Congress can tell the states, all right, we're regulating this part of the field, and this part of the field, you're off. But that until Congress says you're off, the states do have authority to act on the field, in my opinion. So I guess I'm asking, are you taking a sort of Dormant Commerce Clause doctrine on steroids and putting it in the immigration field and saying, this is special, this is a field where just because Congress is here, the states cannot act unless they have clear permission?
So
Is that a question for me?
let's have Nora respond first. So that's the first part of Chris's response, and then Patrick, you can follow.
First, I totally agree, Chris, that I don't think lack of federal uniformity is bad, because we have a very different country with very different case pressures, for example, in courts. Now, on your second point, I obviously agree that this has been a federal law. I think I would go back to your comment about the inability of the federal government to enforce these laws because of the lack of person power to do it. And now when you deputize the states, or when you have a state that passes a law like that, you obviously have much more law enforcement power to do it, and I suspect people are much more willing to call their local police force if they suspect something than they would be to call the feds, aside from the fact they wouldn't even know who to call. So I still have that concern, though I understand why you're probably less concerned about this than I am.
Patrick?
Yep. To clarify maybe my remarks, what Chris knows is that, the federal government has plenary power. They can expressly grant the state on any matter on immigration. I think that's not a question through our history. And the states can work within the framework guided by the federal scheme under preemption analysis. That's my stance overall. In response to the constitutional argument in terms of Commerce Clause or Gibbons v. Ogden, there's a huge difference between domestic and international law. Huge difference in our constitutional scheme. The states have dual sovereignty with domestic law. I know today with the Commerce Clause things have gone amok and the federal government regulates a lot of things, but in the constraints of originalism, that's the difference given to the octane in the Commerce Clause. International law was taken away from the states for a reason, and it's not an integral part of sovereignty for the states to be involved in that. These are not my historical opinion, but in domestic cases they are. So we need to find that framework that works. How far? When do you step too far in the federal scheme? You know, as I said, licensing schemes and things like that, and privileges and immunities of the states. Those are totally constitutional exercises of state power, or even denying immigrants the right of representation in state elections and local municipalities. These are powers that they have. But in terms of foreign policy and entry, exit, or anything about the conditions of their settlement, the criminalization of immigration laws, those are federal issues, at least in my opinion.
Any other cross questions, I guess I would call them, cross questions or observations among the panelists regarding what you've heard from each other? Nora?
Two comments, I think, on both, one on Patrick and one on Chris. And let me start with Patrick, because I've always been very partial, in all honesty, for the longest time, to the argument that states should not be able to do what they're currently doing because of the foreign policy implications. But it strikes me that there are a lot of things that states currently do that have huge foreign policy implications. I mean, on the positive, well, I guess I would say it's the positive side, you have states now sending trade delegations to foreign countries and trying to establish relationships on their own with foreign countries. I think it's economically positive, that's why I'm not so sure it's constitutionally positive. But then on the negative side, in terms of negative foreign policy implications, if I'm looking at state executions of foreign nationals, especially in states like Texas, but also a number of others, where the federal government often tries to intercede and say to the state government, please do at least put it off, and the states have said, we're really not interested in the federal government's input on this issue, and have proceeded with often very negative policy reactions on part of foreign governments. So it seems immigration perhaps a bigger impact because of the number of people impacted, but perhaps smaller impact because the outcry is not of the same magnitude because it happens over a period of time. So that's on Chris. I thought it was quite interesting and perhaps ironic, though not on your part, when we're looking at the decrease in the undocumented population. I think we've always seen these increases and decreases over history, usually tied to just economic situations in the two countries or in other countries that are involved. But you didn't see that circular migration anymore in the last decade because of the border buildup. So in a way, the border buildup, I think, acted to stop the safety valve that used to be there, that people would just migrate back and forth, and perhaps in that way also create a less stable population than we have now. I mean, now we have people who've been here many years and more or less created their lives here. So this leaving, I think, was an option that the federal government has made so much harder because re-entry has become so much more difficult. And then the other question that I actually had, or the question that I had, was triggered by your Sonora example, which is something that I think everybody seems to be tagging on to every scholarly article, but I think real serious thought is being given to this, which is the question of serious focused development assistance to the countries where the migrants are coming from. Because right now we're leaving it to the migrants to remit money home, and then the family can do as they choose with that money, rather than having a structured policy, which may actually be a role for the state, for better or worse. I'm not sure that's constitutionally a good idea, but is that something where the states could be actively involved in if they know that migrants especially come from a particular state abroad or a particular geographic area abroad?
I guess we'll start with a response from Patrick.
Let me make sure I get the question right. The question, how, more or less, if states are impacting foreign policy in other ways other than immigration, what's the difference?
Right, what's the viability, is there any relevance left to that argument?
Okay, I think you bring an interesting aspect of it. Well, I'd like to say that the states do a lot of things that I would say are not constitutionally viable or consistent with their national policy or spheres of government. That doesn't mean, you can go to court about it every time. It's a political issue. A lot of these things are political matters that you'll never see the light of day in court. So, but I think a great example that you brought up was the death penalty and these cases that come before the Supreme Court. And I think two recent where that's a violation of foreign policy. It's going to have foreign policy implications. Well, the difference between immigration and criminal law is criminal law was always a state matter. The federal government really didn't get into this sphere, I want to say, until the 20th century? Decriminalizing anything? In the terms of anything that wasn't in its express powers. But immigration is one of those things that it has, through the law of nations and through a long history of precedent that they have the plenary power. And the states, for the longest time, have had the power over criminal matters, the death penalty, and execution of the criminal law. And I think you can look at any treatise from the 18th or 19th century that will attest to that fact. I don't know, I hope that answers your question in a sense, but, if I was on the state legislature, I wouldn't advise anything that contradicts our national foreign policy. There's a difference between welcoming international companies to say, hey, why don't you come over and invest into my state? Or maybe a foreign delegation, hey, if you encourage your citizens to come over here, I don't think there's anything really wrong with that. It muddles the waters, what's the line? But, I don't think it's as constitutionally suspect as meddling with something that can impact foreign policy with persons, which has always been a big matter. That's what all the commentators have said, that the issue between two subjects of two different nations is a matter between nations. And they never said a matter between local governments. I don't think you'll find anyone that wrote that in the 18th or 19th century. I think today you'll find it, but you won't find it in part of our Anglo-American tradition.
Okay. Yeah, Nora asked about the border buildup and does it impede return migration? I suppose in theory you could get to a point where it might, but I would hope we would avoid that. But I don't think it is right now. It's a really interesting question. I think a lot of people either don't think about the fact or may not be aware of the fact that there is a lot of churn in our alien population in the United States, including in the illegal alien population. People are coming in and they're leaving. They're coming in and they're leaving. Anytime you read a federal transcript of a case describing a particular alien has been convicted of crimes, usually the judge will go through and talk about all these various trips that the alien criminal who's being sentenced has gone through. It's pretty easy to go back and come back into the United States. The quote-unquote wall that Congress mandated in October of 2006, which was supposed to be some 700 miles. Last I heard, it's about 40 miles that have been constructed. So there's still huge portions of the 2,000-mile southern border, not to mention the northern border, that are, there's no real serious impediment to just crossing back home wherever you want. And the other point that bears mentioning is, at our ports of entry, we don't have exit controls. You walk out and no U.S. government official stops you and questions you at our ports of entry. You may notice this when you drive into either Mexico or Canada. You can drive out pretty fast. Now, you will be stopped by the Mexican or Canadian official, but we don't check people out. We only check people coming in. As a result, as we get to a situation perhaps in the future where more of the border does have physical barriers, I think it's important to keep the outflow relatively clear, so people who do want to comply with the law and want to return to the country of origin can do so without a sense that somehow a federal official is going to stop them. Then the second question was about the structural policy of maybe building up these foreign countries that are sending, in some cases they are deliberately. There have been many articles about how the government of Mexico has in some sense tried to make the United States its safety net. I mean, it's really interesting, but they have an appalling safety net in terms of what Mexico provides for its poorest citizens. And that's, I believe, part of the reason why there's a government policy of encouraging, facilitating people to move north and then send back home remittances, because that reduces pressure on their government to actually provide a safety net for their own people. With that said, clearly there's a push and a pull, and we in the United States, both at the federal level and at the state level, can reduce the pull factors, like the magnets, the jobs chiefly, and the public benefits. I think are the two biggest drivers pulling people. But what's pushing are the horrible economic conditions and the economic circumstances of individuals in the countries where they may be sending. And it's interesting because as I thought about this, I thought, wow, has any state ever given foreign aid to some nation in order to prop up their economy? And I can't think of one, but I'm sure California has probably tried. So I don't think there's any legal impediment to a state giving money to a foreign country or financing some public development project, economic development project abroad. There's a huge political impediment in most states, maybe not in California. And so I think that's probably the main barrier that would be there. It's a great question.
Thanks. Other reactions?
Yeah, well, I wanted to, is this working? Can I, oh, sure.
Yeah.
All right. I did have a question I wanted to ask both Nora and Chris, more on policy, but before that, Chris is actually right on this idea of the borders about, it may be an idea to consider about immigration, when you leave. The UK actually has it, depending on the port, you have to see an immigration official from both the UK and then from, like if I go to France, I gotta see both the UK and France person at the same time. It's kind of weird, but it's what they do. They don't do it at the airports, but they do it at like ports and harbors. And interesting experience in Mexico. I went to Mexico not too long ago, and you don't get checked in. Just as no one checks you leaving the United States, no one checks you coming in either. They just look at you. So it's kind of interesting with policies and immigration. But my question, more or less, is I think we're all in agreement that immigration reform is not only necessary but probably imminent with what's going on in the states. But if we do have immigration reform, my question is to both of you is, how much should the states be built into this reform for enforcement? Because I would argue that if there is going to be any enforcement for the future, the states may need to be more involved, at least as prescribed by the federal government.
I think my response is going to be an obvious one. I think that you have to, as a practical matter, if this is an area of law, of federal law, that we take seriously, and we recognize that we don't have unlimited resources at the federal level, the states have to be built into the process. There's one other feature of immigration enforcement that I think a lot of people may not know. It didn't dawn on me until years of working in this area. Federal immigration agents don't patrol. ICE agents generally sit behind a desk and work on cases based on leads they are given, and then they develop a basis for an investigation, say of a plant or an employer or a document production ring or a smuggling ring. They develop, and then they go out and they investigate that particular case. But they don't just drive around in ICE vehicles just looking for people who are illegally in the country. And so as a result, ICE will always be limited because of the structure of the agency, and I think there are some good reasons for that structure. They'll always be limited in their ability to reach to places where the leads aren't developed. And one of the interesting things that happens when you do have state and local law enforcement, because of the importance of traffic stops, which are where most of us will have our encounters with law enforcement in our lives, will be in traffic stops. That is a nexus where the states can provide a lot of valuable information. And we're seeing this in Arizona. One of the untold stories in Arizona is that despite the fact that the political leadership of the Justice Department is suing the state of Arizona, there is a very close working relationship between Department of Homeland Security and Maricopa County deputies, because they are engaged in using traffic stops when the occasion arises to then contact ICE, and because Sheriff Arpaio's deputies are enforcing this anti-human smuggling law, they develop many leads on drop houses and on smuggling rings and on the big players in the human smuggling network, and they give those leads to ICE. And so ICE in Maricopa County gets most of its leads from the deputies who are out there, patrolling, they have many more interactions with the population. And I think that relationship is a really good one. It's mutually beneficial because the states will do what they do. That's part of the way they operate because they're enforcing so many other laws. They're out patrolling, and they can develop leads and contacts and then hand them to ICE. So I think in the future, if we want to enforce these laws, you have to have both.
I love Patrick's positive outlook on life that, what was the word he used? Eminent is immigration reform on the federal level. I have to say I have to disagree with the premise to start with. But as I was reflecting on Chris's answer, I don't think any one of us has any issues with some level of state involvement. There always will be, there always has been at many different levels. I mean, we haven't even talked about workplaces and things of that sort. But to me, I think the overarching question is, are we planning on passing immigration reform like we've done the last few decades, where we're really tinkering on the margins, I argue, and dealing with enforcement-related issues? Or are we looking at the whole construct that is getting us into the problem to start with? Who are we letting in? What are the numbers of people we're letting in? How is it tied to the employment market? I think the problem is that for any category we currently have, we obviously have a huge group of people who are supporting it for whatever reason. And it will be very hard to attack that as a whole. But unless we do that, I think we're back to exactly the debate we're currently having in just a few years, because you'll have a large number of people who are here undocumented. I think the other issue is everyone loves to talk about how complicated the tax code is. Fine. Is anybody talking about how complicated immigration law is? I argue that most lawyers in the country don't understand many parts of it. Sadly enough, there are immigration lawyers who don't seem to understand parts of it. It's a highly complicated area of law, and people have trouble, I think, understanding it. Now, of course, that also means there are some people who understand it really well and are playing the system, but large numbers of people don't seem to understand what happens to them positively or negatively in that system. So I think that's another issue where reform is needed, and it seems to me if we did that, it would actually be easier for the states to assist the federal government, because one of the big issues right now is the training of state law enforcement officers is very difficult, because it's very difficult to understand federal immigration law beyond kind of the very baseline. So I think I'm less sanguine of any reform, and I'm definitely much more pessimistic about real reform. And then we're back to, I think exactly the question we're currently debating.
Give the panelists one last shot before I take it to the floor. I think we're ready to go to the floor. And so there is a microphone here, and I ask you to step up to the microphone, identify yourself, ask your question. A reminder that this is question time, not speech time. So keep that in mind as you formulate what you want to say. But the floor is open for questions, so please don't be shy and step right up.
Thank you all. David Rubenstein, Washington School of Law. So I guess I'm going to direct this first to Secretary Kobach, but I think that everybody's going to have perspectives on this. It ties around to what Secretary Kobach was talking about. I think that the dialogue starts, at least the first line of defense at the state, is that, we're just trying to help. And you brought in as a framing issue, comparing it to drug enforcement. Just as the federal government is involved in drug enforcement, so are the states, and we would want that. But peeling off the first level of rhetoric that we want to help is the fact, at least as expressed by the Department of Justice, is we don't want you. And so when you start with rhetoric, you get to the fact, it leads to a very interesting and I think important legal question, which is to what extent does the fact that the government or the executive branch saying we don't want to help impact the preemption question? And you started, I think, maybe overstated the scope of the Supremacy Clause when you said that only Congress can displace state initiatives. Under the current doctrine, executive agencies who pass binding regulations can also preempt. And by the way, I just wrote an article challenging that premise, because I don't think executive agencies should be able to preempt state law. But that's the current state of the law. But once removed from administrative agencies passing binding regulations that can trump, is really what we have at issue in this case, which is an informal pronouncement by the Department of Justice that what you're doing is interfering with our enforcement priorities. And so I think that that is very much an open question under the Supremacy Clause and under preemption doctrine about to what extent can an informal policy pronouncement preempt. What's a little bit different here is that there is a statutory provision which the restriction of states are so heavily reliant upon, and it's the section of 287 Key 10, which you cited, which allows states to cooperate with the federal government in enforcement of the immigration laws. And so the question is, does that statutory provision for cooperation make the executive informal pronouncement that we don't want your help relevant? And I think that that answer turns on what it means to cooperate. And of course, if cooperation means, as I think it does in some of the same dictionaries that the textualists of the Supreme Court are going to look to, means some sort of mutual agreement. Is it not the fact, possibly anyway, that the statutory scheme is making the executive informal pronouncement that it doesn't want help relevant?
Okay, just jotting down my answers here. Yeah, the states are saying we would like to help, and help meaning we would like to see that these laws are enforced and do what we can to help the federal government enforce. And the DOJ actually, it's more DHS who is issuing the statement that no, thank you, we don't really want your help. This is the argument being made in Arizona. Was made before the Ninth Circuit. And it's a really fascinating opinion. If you find this debate at all interesting, I'd urge you to read United States versus Arizona, but read the dissent too, because the two justices in the majority say they buy the U.S. government's argument that, well, since we don't want their help in this way, they're preempted. And Judge Bea, in dissent, just writes a scathing dissent, and he likens the majority to Alice in Wonderland, twisting the words of federal law to mean the exact opposite of what they mean. And he also chides them for giving... The majority says, onto the foreign policy point that Patrick was making, the majority says, well, there are some governors of Mexico who have protested against Arizona's laws. This has affected our foreign policy, therefore it affects foreign policy, therefore it's preempted. And Judge Bea in dissent says that's ridiculous. That gives foreign governments a heckler's veto. Anytime a state law makes a foreign country angry, the fact that they're angry means the state law is preempted. It's a really interesting dialogue between the two sides in that case. But anyway, yes, you're correct. The executive branch can preempt if they are promulgating a reg which is in the four corners of the statute, right? So, the EPA can preempt state laws if they are drafting a regulation that is squarely within the four corners of the statute, and if the regulation is not within the four corners of the statute that gives them the regulatory power, then that regulation is going to be struck down on those means. So clearly, yes, if they're acting within the four corners. But of course, here they're not. The Department of Homeland Security is saying, well, we've decided that this federal statute that says you have to carry your documents, it's just not important to us anymore, so we're not enforcing that. And that's not an issuance of a reg, it's a very informal thing, and as Judge Bea pointed out in the Arizona case, he said, well, that means that preemptive effect changes with every new administration. One administration comes in and a lawyer at DHS says, yeah, we think this is important now. So suddenly the states are back on the field, and then they come and but we don't like that federal law, that's not enforced. So then suddenly one executive official who's far down in an agency can just preempt the states with this sort of whim. So it's got to have, I think, for our constitutional structure to have any sanity and any sort of meaningful predictability, you've got to have only Congress preempting or an executive agency acting through a regulatory process preempting. But in this particular case, the states are relying on two federal statutes predominantly. 1373, 8 U.S.C. 1373, subsection C is the one that says anytime the state asks, the federal government must answer. And it says must answer. There's no federal government could provide an answer about someone's status if they wish, but shall respond. And so Congress basically said, we don't care whose administration it is down the road, Republican or Democrat, whatever your priorities are, this is an obligation to respond. And the Department of Justice's argument in court has been, well, but we don't want to, because it's going to cause a whole bunch of, we're going to get all these requests from Arizona and Alabama state troopers checking people's status when they write speeding tickets, and we'd rather not spend our resources there. We'd rather go after this subsection of illegal aliens. And the answer there, I think, has been and should be for the states. We have to say, no. Congress says you shall respond. The executive branch does not have the authority to say, well, we have different priorities than Congress did when Congress wrote the law, and therefore we don't have to take seriously Section 1373. Now, the other part you mentioned is Section G10 of 287G, and that one has this phrase: an agreement under this section 287G is not necessary for a state otherwise to cooperate with the identification, arrest, and enforcement of aliens in the United States, in so many words. And so the Department of Justice is trying to twist that word cooperate. You're right, everything hinges on what cooperate means. Does cooperate mean both sides are mutually in accord that this is what we shall do together? But to focus too much on cooperate takes it out of the context. G10 is a section that is trying to give the states authority to act. And it says if a state, nothing in this section of federal law prohibits a state from doing some things to cooperate. We don't read that. Arizona, Alabama, and the states that are acting don't read that as, oh, you have to, we have been given permission in G10 to do what we want to do. G10 is just saying, oh, by the way, this 287G agreement process is not binding on you. And so what the Department of Justice is doing, they're trying to read that language, which really reflects in some ways the 10th Amendment. It has the same structural purpose as the 10th Amendment in the Constitution. They're trying to read that as a restriction on state power because it doesn't fit within the Justice Department's definition of cooperate, when in fact the whole purpose of that section is to broaden or not in any way restrict state power. So it twists that word in a way that's not sustainable by the text, I would argue.
Are there panel's reactions to David's question? Don't have to have any.
I just have. I think Chris hit the nail on the head about the four corners aspect of with the executive stepping in and preempting state law. I think that's the proper legal analysis. But I did want to touch upon, he did discuss the foreign policy debate in the United States of Arizona, and I think he also hit the nail on the head, the way that the court relied on that foreign policy from foreign governors and state officials, United Nations, and so forth. The way that they used it was improper. If that argument would have came from the United States, and the United States would have shown how that has followed foreign policy considerations, that's fine. But from the foreign government to say that's foreign policy considerations, that has nothing to do with it. Now, can that foreign government file a brief? Yes. Should that foreign government be able to file a brief? Yes. But they should do so in the construct of the U.S. law and argue it, or show a treaty unilateral agreement or something to the fact that, hey, this is how it's impacted. We had this agreement, and this is impacting that agreement, and that's totally an exercise of their power within the courts. But the way the courts framed it was rather the dialogue was very interesting.
Other questions?
Thank you. I really appreciate the discussion today. My name is Ann. I'm the state representative. I wrote my question down so I don't ramble. I want you to understand why we don't have an Arizona-type law in Kansas, and then get your opinion where I'm headed is on immigration reform. There are lots of ways to go about addressing the problem. In light of lack of federal action, you can only imagine how frustrating it is here at the state level to deal with all these issues. We've looked at all the potential bills that are out there. Throwing nuns in jail for running soup kitchens is not palatable. Our jails are packed now. Just this last session, we opened up 123 more beds in state prisons. There were 122 prisoners waiting to fill those beds. Our county jails are packed. They would really appreciate it if we did not put them under some obligation to house prisoners for whom they have no room and no money. As the Secretary mentioned, one thing you could do is to ratchet up the pressure to reform the law. That's one of those be careful what you wish for In fact, the ag groups and the state chamber killed that Arizona type law here this year. They recognized and said so on the House floor that we could not get our crops in without these workers. So it was actually the conservatives in the House, even the Speaker wouldn't vote for the Arizona type law here. We are not for a welfare state. In fact, the state legislature spent $1 million to review who was getting welfare benefits in the state. 20,000 files were reviewed. For that $1 million, we found one illegal immigrant. So we think we're doing a pretty good job of not being a welfare state. And nobody believes anybody's going to haul 12, 20, how many million immigrants you think are here illegally. I, in fact, personally handed ICE a case against rebar setters in Kansas City, complete with illegal Social Security numbers, and say, go take these guys out of business. They wouldn't act on it. So the frustration grows. I get that. I think part of the solution is a workable, expanded guest worker program so people can come back and forth across the border, do the seasonal work that they need to do, and also maybe a path to citizenship for some of these kids that we have literally spent billions of dollars to educate who want to stay here and be good citizens. So my question to you guys, particularly the Secretary, instead of passing local and state laws that make it worse, what is the right answer to immigration reform? How do we get to a point where all of these local, county, and state governments can take the Chris Kobach retainer line item out of their budgets, and we can have a solution that really works? If you guys were president for a day, what would be your immigration reform answer? Thank you.
Okay.
Well, the short answer to the final question at the end of that was that what would your answer be today? I would say that the federal government should do something that's never been done at the federal level. Try a strategy of attrition through enforcement. Before we say that to be sure, there needs to be some changes in federal law, but to say that, oh, it's just broken, I think that's just, frankly, a cop-out. We have never actually tried significantly ratcheting up the level of enforcement nationwide of our immigration laws. Never been done. You may recall back in the 1990s, the Clinton administration thought about doing that in the workplace. Ratcheted up enforcement, did some worksite raids in Nebraska, Lexington, Nebraska, you might remember that one. And the Nebraska congressional delegation immediately complained to then the INS, saying, oh, don't do this, we're not ready for this. And so that little slight increase is about the most we've seen. And then in 2005 to 2008, the Bush administration, you saw a very significant increase in worksite enforcement. Complaints like that in Nebraska incident notwithstanding, and you did see a lot of people self-deporting or leaving the United States because of that. But then the current administration has pretty much ended worksite enforcement in the form of raid. They do now I-9 audits. But I would say a few things in response to Representative Ma. I would say that I think it's incorrect to state that the reason House Bill 2372, which was a Kansas bill that did sort of an omnibus immigration bill, the reason it didn't come out of the House is because the ag groups killed it. I think if you asked Representative Reichman or DeGraff, also sitting in this audience, why did that bill not come out? I don't think I doubt anyone would say, oh, it was killed by ag groups. There are a variety of reasons why that bill didn't come out last session and may still come out, or something like it may come out in the coming sessions. Secondly, the notion, it is true that some in Georgia have complained that that state's law has caused so many illegal aliens to leave that there aren't enough people available to pick crops in the field. And it is certainly true that in agriculture in particular, if you have types of crops that require people to manually pick them, which Kansas is not one of them, we don't have that kind of agriculture here. But if you have that kind of agriculture, yes, and if the law kicks in at a particular time of year, there will be some economic pain by the producers, because if they have been relying on illegal labor and suddenly that illegal labor is no longer there, then suddenly they're going to have to make a bid in the marketplace for legal labor. And as a result, that means that wages have to go up. You look at any industry where illegal labor has a prominent place, it drives down wages. Meatpacking is the classic example of it. We've got lots of data on that. I mean, people made a good living in meatpacking and supported families in meatpacking 30 years ago in America. Now, it's one of the few industries where wages are lower in actual dollars today than they were in the 1980s. As a result, if there is a federal enforcement action, wages have to come up in order for U.S. citizens and legal aliens. By the way, legal aliens are being displaced out of those jobs too by the illegal labor, because the legal aliens are not as easily exploitable, and so they will demand a higher wage. So wages do have to come up. And I mentioned one other point in response. Alabama has a huge meatpacking industry. It's mainly poultry processing. Marshall County, Alabama, is probably the county that has the highest concentration of poultry processing. And one of the city council members of Albertville reported in the press there that over basically the last month or so, a few weeks after the Alabama law went into effect, he reported that he observed a line outside one of the meatpacking plants that was about 2 blocks long of U.S. citizens of every race lining up to take jobs that were now open because illegal aliens had self-deported or had removed themselves to elsewhere. And I think that's a good thing. We've got 14 million plus Americans unemployed. Why in the world would we want to say, well, we're setting aside these special low-wage jobs where we exploit illegal aliens, and U.S. citizens aren't going to get those jobs? We're not really concerned about putting U.S. citizens in those jobs. On the contrary, we should open them up, and we should encourage a legal wage to be set so that U.S. citizens can try to support their families, and aliens who are abiding by our laws can support their families at that legal wage. And that's what's happening in Alabama. So I think it's a good thing. Will there be some temporary dislocation if it happens in a state where there's, the crops need to be picked right now? Yes. But markets react and wages come up.
Other thoughts about what your ideal federal policy might look like?
I suspect this is the best example of how Chris and I probably fundamentally disagree. I hate to say that I think life is so much more complicated than this. I do agree that probably our wage levels on agricultural labor, meatpacking, a lot of these industries are much too low. Of course, if that's accurate, we have to deal with the fact that consumer prices will be rising, and we have to deal with the fact that we have a 9.5% unemployment rate. And that probably some of these agricultural products we really want people to eat, and we know that there's a substantial portion in the population who already cannot afford them. So it's a lot more complicated, I think, than we're making it out to be. I don't even want to get into Kansas because I know too little, and I don't want to use any example. But if you're looking at New York City and Long Island, the agricultural industry is on the eastern end of Long Island, which is at least a 2.5 hour drive from New York City. If you're looking at the big unemployment blocks, they would be in parts of the inner city of New York City. Aside from the fact that many of the people there who are unemployed, who are United States citizens, who could use a job that would presumably be available in these agricultural areas, and the same holds true for upstate New York, probably wouldn't be able to tell you what kind of crops these are. And this has nothing to do with education levels, incidentally. They're very well-educated New York City people, and you can laugh, and they won't be able to tell you the difference between a cow and a sheep. And I'm sadly not joking about this. But what I'm trying to tell you is, it's very difficult to move an urban population where you have a lot of these unemployment blocks into agricultural areas and expect them to be useful employees, surely the first time around. And I think I've read enough about the literature to understand both sides on this. This is very difficult, very hard work, and wages may make a difference, they may not. But it's not as easy as doing this because you'd have to relocate those people. Transportation isn't available in the inner city, even within parts of New York City, the 5 boroughs, let alone out to the eastern shore of Long Island. So this idea kind of moving people in this way, I think, would require a lot more centralization and not just higher wages. In terms of total enforcement, at least in the part of the world in which I live, what this would mean is tearing large families apart, putting people in detention who actually have access to immigration benefits, but they also needed access to a lawyer in order to be able to benefit from those. I can tell you we have an asylum clinic that gets asylum for 100% of the people who are coming to them, but without a lawyer, not one of them would, and that's not because our clinic is making up facts, but they're creating a record and they understand what the law is. So I think, as I said earlier, immigration law is unbelievably complicated, and we need solutions other than enforcement, and that seems to me the baseline of the issue. Now, if we did what Chris is suggesting, I suspect we may actually see a very different consequence from it, because you may actually see large-scale demonstrations in part of the country, not everywhere, but in parts of the country where you are in fact having unbelievable impact on local communities and families. So in a way, that may lead to actual action, which I do not see forthcoming.
I think it's a great question because I want to be president for a day. But as president, of course, I couldn't enact any laws, but I could suggest to my party and Congress a couple following guidelines, I think. I think anything to be suggested has to be consistent with the idea of a healthy assimilation as well as healthy enforcement. And you can't have free migration, you can't have exclusion altogether in this idea, but there's going to have to be some kind of balance in between. I think one responsible way is something Chris mentioned, which is state assistance. But if we did do that with any kind of immigration reform, I would say there has to be a myriad of safety nets for civil rights violations, and states would need direct guidance. It couldn't be some broad term thing that we have now about states asking for federal assistance. It needs to be a lot better outlined than what it is. And I say that mostly because if I was president, I'd be fiscally responsible. So I think that's a way to be fiscally responsible, is to put that on the states. And then, you can use the power of the purse, to do things like require states to use E-Verify. I mean, I know people don't like to hear that, and I think people think E-Verify is flawed, but the Supreme Court and Chamber of Commerce in Wyden show with the statistics that, it really isn't that bad. It has a quick turnaround, and it is a national solution to a problem. It may not be perfect, but nothing will be perfect ever. Our Constitution's not perfect. Another good idea maybe would be an actual express law by Congress preventing states from issuing municipal IDs or getting state driver's license. I know we probably disagree on that because people need to get to work and people need to drive, but that's the basis of the way people get services. Maybe people can get voting rights, or they can find ways to violate the law. And then the last one, it's an extreme one, and I talk about it in my BYU Journal Law Review article, is I think, you may want to politically exclude unlawful aliens from federal enforcement. You do a census, and you do the census based upon legal residency and citizenship, and that's it, because that's part of the inequality that we're dealing with right now, is that you're giving, and people aren't mad about it, you're giving political representation to people that we haven't acquiesced to. And if our government's founded on consent of the governed, then that is a quick way to get, to maybe do enforcement, and it costs nothing. I mean, other than the same census costs we already have, and the same thing with E-Verify, little cost, or state assistance, maybe little cost, because if we do like maybe strict enforcement, there's a lot of costs associated with jailing and enforcement and going around and doing these things. And just like 1986, you got to do the humane way in some way to balance it all out. So I hope that answers your question.
We have, I think, about 5 minutes left before we break for lunch. So with that 5 minutes, I guess I would offer the panelists if you have any quick nuggets you'd like to send the group off to lunch with, I invite you to do that now as part of a quick summary, and then we'll wrap things up and head to lunch. Chris, any closing comments?
Yeah, just returning back to where we started, just to give you all an update. There's a lot of movement in the courts on this right now. We expect to see on this very issue, I mentioned that we had the Supreme Court ruling in Chamber of Commerce versus Whiting, but there are some circuits that are going to be ruling pretty quickly here. You're going to have the 11th Circuit probably rule in the Alabama case and the Georgia case. They may combine them, I'm not sure, or they may rule something that's still unclear. Probably in the next let's see, the briefing, I'm trying to calculate the briefing schedule. I would say within 6 months we'll probably have something on the 11th Circuit. The 5th Circuit in the Farmers Branch case is probably going to rule in the next 3 months if they keep to their normal schedule of opinion writing. The 3rd Circuit in the Hazleton case, 3rd Circuit takes longer than some of the other circuits, so I would expect to see that maybe 9 months down the road or so. So you're going to have 3 circuits weighing in on this very issue in the wake of Whiting. So if you find the legal analysis of all this interesting, keep an eye on those cases. Again, the Farmers Branch versus Farmers Branch in the 5th Circuit, U.S. versus Alabama in the 11th, and Lozano versus Hazleton in the 3rd.
Thanks, Chris. Nora, any closing comments?
I think as you're watching those court decisions, I think at the same time you probably have to go to the inner pages of the newspaper if you're still reading it in print copy to see, I think, the counter developments to that. You'll see a whole host of states taking anti-enforcement steps or other steps to protect their population, including their undocumented immigrant population. I don't think that'll be generally on the front pages of the paper, but you will definitely see those developments. I think the other thing I would start paying attention to is credible studies, and I consider the studies coming out of the federal government to be credible studies in terms of what is happening with this immigrant population, where they are going, where they are not going, and ultimately, and this is a long-range thing, if you can remember this in 10 years, which of the states are benefiting the most from this movement, and including the movement of undocumented immigrants into their states.
Thank you, Nora. Patrick?
I have really nothing to add other than I said before, so I won't bore you with that, but I did want to thank my panelists. I think this has been a good exchange, and I've had a good time here so far with this exchange, and I hope you guys have learned a lot about immigration and the constructs and the difference between good policy, effective policy, and our options that we have available, and at least keep those considerations in mind as you move forward with immigration reform. The debate is often centered in terms of hate on both sides, and then you need to escape that in terms of crafting good policy. Just because you want enforcement doesn't mean you hate, and just because you don't want enforcement doesn't mean you don't hate, because the sword has gone both ways. So I just want to leave that for food for thought for everybody, and thanks everyone for attending.
Let's thank